Hi, everybody. It's Monday morning, 7 a.m., June 17th. And once again, it's time for another edition of Politics by Jake. This is the semi-weekly thing that we do, which is a historical and political analysis. And the emphasis is on history because, as I say so many times, we know here at Politics by Jake that you are getting a multiplicity of sources that are reporting certain aspects of the news to you. For example, like I used the example that pretty much everybody knows now that Donald Trump is 34 times a convicted felon. We know that you know that, and we don't think it's necessary to rehash that and repeat that again in the precious little amount of time that we have on this show. But what we want to do is we want to look at these. Number one, we want to report certain political events that we don't necessarily give a summary of all political events, but there's a lot going on, as I said. So we focus on several things that are crucial, and we view them partly from a historical aspect. We do go into history, and mostly history of the last 100 years. And one of the reasons that what I say the last 100 years is because we have a fascist uptick that has been going on really for quite a long time, and about which you have heard me speak many times. And you will always hear me say that if you don't know the history of a thing, history is cyclical, and when it comes around again, you will not be aware of it. And things that have already been decided, and sometimes decided in blood, will yet be undecided in your mind simply because you don't know what went before. And it's important, therefore, to be so apprised. So that's what we do here at Politics by Jake. That's one of the things we do. And another thing that we do is we think it's fine if you want to listen to the show. We encourage you to do that. But we also want you to take action. It's important that we present a united front. And so one of the things that we talk about quite often is things that the individual listener can do. And as an individual listener, you can do these things. And we try to point out ways that you can get together and form a united front, or even just by the water cooler in your individual and several instances, as they may be, and talk about some of these things. So with that said, let's get going. And we're going to be talking about the court today. And now let's pause for a brief commercial message. Hi, this is Jake with Twain Consulting, and I'm back again to talk to you about one of these little wrinkles that can cause a lot of problems and a lot of happiness for people who actually want to own a business, or who have just started a business, or who have been operating a business now for some time. It doesn't really matter. My guess is that you wanted asset protection. That's one of the reasons for starting a business. You wanted to grow wealth, and you wanted to protect the wealth that you created, and you thought that a limited liability company or a corporation would be the way to do that. But did you know that just creating a corporation or a limited liability company does not guarantee that at all? Do you want to know if there's any way to fix that? Go to www.jakelaw.me. That's JAKELAW.me, and watch my video where I talk about this very important thing, and then set up a time where we can have a phone conference, or call me directly now at 573-454-1168. That's 573-454-1168. Call now. And now let's get back to Jake and Politics by Jake. So now, as I've said, we're going to have more to say about the court. And when I talk about the court, I'd be talking about the entire judicial system, but I'm specifically talking about the Supreme Court. And we all know that they've been in the news lately, and there's been some extreme problems about that. And I will take the one that is most recent first, and that's Judge Upside Down Sam, as I like to call him, Upside Down Sam Alito, who doesn't believe in stare decisis, and who doesn't believe in res judicata, and who thinks that it's okay to refer to 13th century sources to support his views on abortion. These are all things that he said in Dobbs v. Jackson Women's Health Organization, which was the 2022 case that basically ended federal protection for abortion in the United States. And then, of course, you have his concurrence in the absolutely positively horrifying per curiam, and by the way, per curiam, that's Latin P-E-R, and then curiam, C-U-R-I-A-M, which basically means through the court. That, in other words, the entire court. This stunning 9-0 dismaying decision in the case of Trump v. Anderson, which just happened recently. March 4th, 2024 is the date it was submitted or decided, and basically invalidating Section 3 of the 14th Amendment, which had been in existence since, the late 1860s, and which once again violates stare decisis, which means let the decision stand, which means in no case do you have a situation where, when there is well-established law, you do not overturn it and you do not negate it. There has to be an extraordinary situation in order for this to do so. And as I said, many submissions, many amici curiae, which are, once again, Latin. You'll excuse me, as regular listeners to this show know, I took 6 years of Latin in high school and in college, and I thought I was going to be an archaeologist, and that didn't work out. But by golly, I'm going to get my Latin in somehow if I have to, so just be patient with me. I usually provide the translations, and amici curiae means friends of the court. And there's something that you can do with the Supreme Court if it's soliciting briefs. And briefs are actually basically memoranda stating or advocating a certain point of view, whether it be a supporting point of view or a contrary point of view. And the Supreme Court actually has pretty much always encouraged the submission of these. It puts out a request for amici curiae or friends of the court briefs, and then various people are invited to respond, and they do. And there's not one of them that supported this sweeping 9-0 view of the invalidation of the 14th Amendment, Section 3. And this has stunning implications, too, for the case that is coming up for decision, which we've already had oral arguments on, with regard to presidential immunity. And this is part of the terror, and this is part of the corruption of the Supreme Court, because one of the things that this case did, Trump v. Anderson, is it basically said that in the face of all of these reasons, and these are not dummies, these are just not the man on the street as submitting an amicus curiae with regard to the subject. These are reasoned and intelligent and astute legal practitioners and legal historians who did this. And in contravention and a slap in the face to all of that, and on literally unanimous grounds, they rejected a law that's been in existence for well over 100 years, which is just this is startling. And of course, Alito didn't give the opinion and he didn't even give a concurrence or any comments. That's when a judge agrees with something, but he has some additional things that he wants to say. And that's his prerogative or her prerogative to do so, and that happens all the time. But it was just a sweeping view. And you can argue that the reason it was a per curiam was that nobody wanted to be the fall guy and to take responsibility for invalidating this well over 100-year law, which is actually an amendment to the Constitution. This court attacked the United States Constitution, and they invalidated one of its legitimate amendments, which is well thought out and well considered for so many reasons that there is just not enough time to go into here, and they just completely sweepingly invalidated it. So Alito was part of that. We can't pin that on him specifically as being the fall guy because, of course, it's a per curiam decision by the court, through the court, unanimous, 9-0. And they did this, I think, as much to protect themselves as anything else. It violates the doctrine of stare decisis, violates res judicata. And as I said, res judicata is a companion doctrine to stare decisis. They violated that. They basically have shown that they are perjurers for the Senate Judiciary Committee and the Senate, because they always ask them, do you believe in stare decisis? Do you believe in res judicata? And they're, of course, they're all coached and they're all told what to say. And it's like, oh, yes, we all believe in that. Oh, yes, we would never disturb that, and so on and so forth. But when push comes to shove, when it really counts, we see who they are. And this is a group that is all too willing to violate and destroy the United States Constitution. And this is something that should be of concern to everyone within the sound of my voice. And there should be a continued hue and cry and an uproar that should never cease with regard to such action. Because what this does, and unfortunately, because of Bush v. Gore, which actually did this, in which the United States Supreme Court ordered a sovereign state and interfered with its elections and basically told him to stop counting its votes, in which case it was found out later when the counts were done that a person other than the person who was installed in the presidency, which is George Bush the Younger, one of the worst presidents that this country has ever had, George Bush the Younger, was installed, and it was installed because of this, and this violated the sovereign right of a state to conduct its own elections, which is well established, or was until that time, well established in law, was decided by a reactionary and fascist justice, which was Scalia, whose father was a Nazi or was a supporter of the Nazi. And, honestly, if you want to say, well, Jake, he wasn't a card-carrying Nazi. I'm not so sure about that, and I'm not so sure that it matters. Because, for example, I call a fascist anyone who has, number one, backwards, and we call those reactionary, backwards political beliefs, like, for example, women shouldn't have the vote. That's reactionary. Chattel slavery should be reinstituted. That's reactionary. And who support or participate in acts of violence in order to support these views. That's fascism. And now let's pause for a brief commercial message. Hi, this is Jake with Twain Consulting, and I'm back. And what I want to talk to you about now is something I call virtual invisibility. No, not literal comic book type invisibility. What I am talking about is a practical invisibility, a kind of invisibility where you cannot be seen, where your personal transactions are shielded, where your business affairs are hidden from prying eyes, where a purchase of certain items is far less likely to be able to be found out by persons who have an intent to do you and your loved ones harm, the kind that results in the preservation and the protection of your personal assets, your business assets, all for your benefit and the benefit of your loved ones, the ones you are doing all this for in the first place. That's virtual invisibility. Crazy, you say? No, this exists. It's a thing. Want to know more? Contact me either at my website, www.jakelaw.me, or call me direct at 573-454-1168. Do it now. Become invisible now. And now let's get back to Jake and Politics by Jake. That's a good working definition of fascism. And as a consequence, I say that these are fascist judges because they supported that. And they interfered with longstanding doctrine. And once again, this is Scalia, but it was the decision of the court. It just wasn't Scalia that says this was. Scalia was just like, he was the fall guy, as it were. He was the guy who was willing to put himself out there and do that. So they've been doing this, and ever since this happened, they've been losing credibility for the past, well, that was in 2000, when a president was installed by the Supreme Court instead of elected by the vote of the people, which is the way it should go, obviously. And now they're doing it again, and they're invalidating the Constitution again. And one can only express a sense of extreme trepidation and impending doom as to what the decision is going to be with regard to presidential immunity. And I'm telling you, it doesn't look good. So everybody hold on to your hats. But I say all these things basically, and I've mentioned Upside Down Sam, as preface to what's going on now, because apparently there is more going on with regard to Upside Down Sam and a tape that has come out discussing how the Battle of America, and it's phrased as the battle, and I guess I can't get too mad about that because I guess it is a battle. It can't be compromised. And he basically says, and this is from Rolling Stone, and I'm going to be referring to that. And to give proper credit, this is by Tessa Stewart and Tim Dickinson. And the date on this is recent. It's June 10th, 2024. And they say Justice Samuel Alito spoke candidly about the ideological battle between the left and the right. And this is something that at Politics by Jake we've been talking about. You have reactionary justices. You have ideologues who are not deciding things according to established procedures. You have Amy Coney Barrett, for example, who says that it's, and trust me, she says this, that it's okay if you have a case and it violates what the scriptures say, it's okay to ignore what the Constitution says, because you should decide these things according to what Scripture says. And Amy Coney Barrett is part of a Catholic, which you could say is kind of an ad hoc organization, but it would be kind of in the same way as you would say the Jesuits is an ad hoc organization. And it's there are several of these. The Jesuits is one. There are several. I wouldn't want to allow as how it's just the Jesuits. But there's another one called Opus Dei, and they are fanatics. And you have another one called the People of Praise, and they are fanatics. And she is one of them, and we have talked about this before. And this view of desiring that the scriptures, which are intensely problematic, and I realize that a lot of my listeners they read the scriptures and they have great concern about the scriptures, but there are so many different views that, as it says in one part of the scriptures, you're going to have to come to the point of time where you have something called a unity of the faith. And there is no unity of the faith. So all these things are highly subject to personal opinion, and even the opinion of educated people who studied the scriptures all their lives. And this is what Amy Coney Barrett thinks ought to be the criteria instead of the law, on which there is far more unity because it's all case law. It's all established decisions. But unfortunately, this is what you're dealing on, and we find that Upside Down Sam is one of these. So we talk about, and they talk about in the article, Tessa and Tim talk about the difficulty of which Alito expressed of living, quote unquote, peacefully with ideological opponents in the face of, quote unquote, fundamental differences that, quote unquote, can't be compromised. And this occurred on June 3rd, once again, pretty recent, at a Supreme Court Historical Society annual dinner. And this is a place where right-wing activists have an opportunity to talk with Supreme Court justices. The comments were recorded by someone named Lauren Windsor, who is actually kind of a plant. But she was invited to the dinner. She's actually a liberal documentary filmmaker, and she's a dues-paying member of the society, and she did it under her real name. So, I mean, it's not, it's not really that bad as far as deceit or anything like that is concerned. So you have her actually questioning Upside Down Sam and basically saying, I don't know that we can negotiate with the left in the way that needs to happen for the polarization to end, close quote. And also, quote, I think that it's a matter of, like winning, close quote. Alito says, I think you're probably right on one side or the other. One side or the other is going to win. I don't know. I mean, there can be a way, and I'm quoting him now, a way of working, a way of living together peacefully. But it's difficult, because there are differences on fundamental things that really can't be compromised. They really can't be compromised. So it's not like you're going to split the difference, which is interesting because politics is all about compromise. If you don't have compromise, you have fanaticism. And Windsor is talking to Alito and says, quote, people in this country who believe in God have got to keep fighting for that, to return to our country to a place of godliness. And, close quote. And I guess she is kind of baiting him here. I guess that really is happening. And he says, quote, I agree with you. I agree with you. And then you have even this more recent situation where Sam Alito and his wife were captured in secret recordings that featured the justice discussing the country's left-right divide. And Martha Ann Alito, and that's his wife, implied she would take revenge on media outlets that reported on admittedly and honestly controversial flags that were flown at Alito family homes. And they quote her as saying, look at me, Martha, I'm German. I'm from Germany. My heritage is German. You come after me, I'm going to give it back to you. And I sit here and I think, oh my goodness, what is this? Because, the obvious implication, because she is of the age, this is what is this Hitlerian Germany? Is this Nazi Germany? Is this like fascist Germany? Are you like embracing the fascist heritage of Germany? Is that what you're talking about? So this is all completely problematic. And once again, these are red flashing lights for us all to pay attention to. And it's one of the things that I talk about on Politics by Jake that we need to understand. I know that you know certain things. I'm not going to tell you about those things because I know that you're already getting those things from a multiplicity of sources. But stuff like this, stuff that really has an impact, that shows who the players are and what it is they're doing, we're definitely going to talk about. And this is one of them. So you have this continually and incredibly problematic situation with the court. Alexandria Ocasio-Cortez has been talking about it, and there's much more that could be said. We have another segment that's going to be coming up, and I'm going to be talking about Clarence Thomas and the almost comical, but tragically comical situation with him. And we'll be talking about that in a minute. And this is Politics by Jake. And now let's pause for a brief commercial message. Hi, this is Jake with Twain Consulting, and have you ever tried to get a business credit line? If you did, what's one of the unpleasant things that you found out? You found out that the only way that you can get business credit is if you personally guarantee each and every single loan, each and every single commercial credit line. Now, let me ask you this question. How did that make you feel? If you're like me, I would feel like they were giving with one hand and taking away with the other. If this bothers you, I encourage you to go to my website, www.jakelaw.me, where I talk about this and several other important products and services that can benefit really almost all people listening to the sound of my voice. Call me at 573-454-1168 so we can talk about this, get mad about it together, and see if there isn't some sort of solution. That's www.jakelaw.me. That's JAKELAW.me, M-E. That's www.jakelaw.me, and the phone number is 573-454-1168. And now let's get back to Politics by Jake. He's talking about some very interesting things here, and you'll want to stay tuned. So without further ado, back to Jake. This is Politics by Jake, and we're back. And I promised in a previous show, a couple of weeks ago now, I guess, that if I had the chance, because one of the things that we're talking about as a reading segment on Politics by Jake, the real PNB, PB&J, none of that, peanut butter and jelly stuff. That's not the real one. PB&J, Politics by Jake. Shameless plug. We're talking about the really corrupt, and it's a shame to have to say it, but it has to be said, corrupt Supreme Court and the extent of that corruption. And I talked about Alito a bit. I've talked about Barrett a bit. I've talked about Kavanaugh a bit. I've talked about some shocking statements by justices who should be progressive but are not, who embrace what Politics by Jake considers the judicial heresy of originalism and textualism. And of course, I'm talking about Elena Kagan. And this is shocking because she's supposed to be, and it's also telling. It's also, it's shocking, but it also is orienting because she's supposed to be a more progressive justice. And yet she's indicated that she's a willing partaker of the judicial heresy, which is no more in evidence than it is in the Supreme Court of today, of originalism. And we've talked about that, and I don't intend to go into it now at great length. And to my way of thinking, the doctrine of originalism is actually one part of a larger doctrine that I call legal positivism. And I mean, let me not make a claim for the originality here. I'm not the only one who coined the phrase legal positivism, and I'm certainly not the first. But it takes two forms, and one is originalism, and the other is textualism. And they're constitutional and judicial heresies. And for someone like Kagan, especially, it would be a heresy for any of the other justices to talk about this and say that this was their guiding light as far as deciding cases were concerned. Justices like Barrett are just completely off the charts with regard to this, because they don't even consider, and I realize that this is a radical statement I'm making, but they don't even consider the Constitution the final word on judicial decision of cases. And Alito is the same way. And he proved that in Dobbs v. Jackson. And we've talked about that, and we'll talk about it again. It's just completely ridiculous. It's completely reactionary, and it partakes of this heresy, which is in a more general way called legal positivism. But like I said, the two main elements of it, I would say, are originalism and textualism. And originalism violates the progressive nature of the Constitution in several areas. Ninth Amendment is one of them, and the preamble is another, where it talks about the need to create a more perfect union, which originalism just completely expressly violative of, because originalism says that you're supposed to take, and I guess I wasn't going to talk about the definition, but it's necessary to remind you guys of it. And that's okay. Just bear with me. I won't spend a lot of time on it. But it says that you're supposed to take the plain language of what the Constitution says, and you're supposed to rule based on the plain language of the Constitution. And you run into all sorts of problems with this, because the original document is, because they pick and choose, you see. The original document, you could have slaves. And so an originalist like Roger Taney, who was the Chief Justice of the Supreme Court during the time of Lincoln, could, in the slaughterhouse cases, could make a case for the perpetuation and the continuation of slavery based to a great extent on what the Constitution said. But this is heretical. It is obnoxious to the sentiments of Americans and everybody over the world. Chattel slavery, to make a human being like a chair or a table or a plow or a hoe or some other implement like that, a farming implement like that. But this is what it is. And then you have, of course, Alito in the case on the 14th Amendment, violating his own doctrine of originalism, because the 14th Amendment, incredibly clear, and you actually have the whole court concurring with him. This is one of those rare 9-0 judicial statements, and they all violate their own doctrine of originalism, because when you read the text of the 14th Amendment, Section 3, it's exceedingly plain. And I didn't want to deviate so far down the road on this, but we've talked about it before. We'll talk about it again. But this is stunning. This is stunning. So in other words, you have express proof that the Supreme Court is completely off the rails. They talk out of both sides of their mouth, and whatever they decide that they're going to decide is the decision. And originalism doesn't matter. Stare decisis doesn't matter. Res judicata doesn't matter. Nothing matters. And so, so in addition to this, you have this rank corruption. And I talked about this with regard to Barrett and Alito and Kavanaugh. And I started talking towards the end of one of the shows about this with regard to Thomas. And I had so much material, I literally wasn't able to get to it all before the show ended. So I promised that I would talk about that again and do a segment where that is just stated pretty much in full, or appreciably in full. So that's what we're going to do on this segment. And that was sure a long prefatory note on that, but here we go. And the reference on this, by the way, for those of you who want to look up on the internet, is Forbes, and it's their article of approximately on or about October 26, 2023 at 4:56 a.m. The person who was doing it, Allison Durkee, who is a senior news reporter covering U.S. politics and legal news, she uploaded it. It was an early morning for her, but that's the way it goes in journalism sometime. So let's talk about that, and some of this is going to be repeated. For example, Thomas had a recreational RV, stands for recreational vehicle loan, was forgiven. He got a recreational vehicle. If you look at some of the videos of him, he apparently likes to do this. He likes to drive around in recreational vehicles with his, I'm sorry to use this language, but his right-wing reactionary fascist wife who supported the insurrection and was deeply, deeply involved in it as far as giving aid and comfort to the insurrectionist, Jeannie. And the thing about Thomas is that when you read about Thomas, he was incredibly poor at one time. And this is compelling for more reasons than one. And I'm going to refer to Wikipedia, the Wikipedia entry on him. Thomas was born in a place remarkable called Pinpoint, which is in Georgia, the same state that Marjorie Taylor Greene represents, one of the districts that she represents. His father abandoned the family. He was raised by his grandfather in a poor community called near Savannah. He had intended to be a priest, but he was able to attend College of the Holy Cross, and he was able to attend Yale Law School. And he's one of these people who, in spite of his upbringing, seems to have gone in what I think you would have to say is a counterintuitive direction to his poor upbringing and his poor surroundings and his important association on just a fundamental and basic level with those who were like him, who were not only African American, but, who tended to be poor, like he found himself in the condition of being. So, unfortunately, he was influenced by a number of conservative authors, and he was appointed, after he graduated from law school, he was appointed as the Assistant Attorney General in Missouri. He later entered private practice in there. There, he became a legislative assistant to U.S. Senator John Danforth in 1979. He was made the Assistant Secretary for Civil Rights, which, again, based on what he talks about, extremely counterintuitive. In 1981, Ronald Reagan appointed him as the chairman of the Equal Employment Opportunity Commission in the next year, extremely counterintuitive. Once again, President George Bush the Elder promoted or nominated him to the United States Court of Appeals for Columbia, which is said to be a stepping stone, a primary stepping stone to the Supreme Court, and that was in 1990. He served in that role for 19 months, and like I say, it's a stepping stone. People who serve in the D.C. Circuit are on the short list as far as nomination to the Supreme Court, although not always, but it tends to be that way. So he was there for 19 months. He was nominated for the Supreme Court. He filled Thurgood, the outgoing Justice Thurgood Marshall, who was a very interesting fellow and made some very interesting comments, such as that the Constitution, as it was delivered in 1789, was dead on arrival. And of course, because of one of the big issues was because of chattel slavery. And he, getting back to after Scalia died, many have said that he's the foremost originalist on the court. And he stresses the original meaning in interpreting the Constitution. And this is just extraordinary. And now here's a word from one of our sponsors, Twain Consulting. Hi, I'm Jake with Twain Consulting. For my great product, Get It in Writing. Did you know that the Wall Street Journal, Entrepreneur, Inc., all prominent business periodicals say that 80% or more of all businesses are operating without the proper stable of business forms, and that there are 10 absolutely positively essential business forms that businesses should have, but that they don't have? As a business owner, do you want to avoid growing pains in your business? Do you want to minimize client confusion, missed opportunities, bad business dealings, lawsuits? Well, that is what Get in Writing is designed to do. This program is designed to keep you out of trouble, streamline your business, and make you more profitable. If you were to go out and buy all these forms individually, you could wind up spending more than $25,000. $25,000! Amazing! But if you take advantage of this opportunity, you will spend far, far less than even $1,000. Go to my website now, www.jakelaw.me, or call me now at 573-454-1168. Call now! Save now! And now let's get back to Jake and Politics by Jake. But he's not the only one. Alito is like this. Kavanaugh is like this. Barrett is like this. And this is just an extraordinary thing for someone like him to do. It's completely counterintuitive, and many people have looked upon him with disdain and scorn purely for his legal and judicial views. And I recommend, because there's a lot here about him, I recommend that you go to Wikipedia and read about him, because once you find out about him, his stance seems all the more extraordinary, because he, like I say, he was born poor, and there's no reason for him to say some of the things that he says, and it's just a conundrum wrapped in an enigma, encased in a riddle, as to why he talks the way he does. But he has fallen afoul of financial corruption, and it is that to which I primarily, after these prefatory notes, wish to address my remarks. So we have this RV loan, and this is great because he's attained great prestige and significant wealth coming from this very, and I won't say low status, but I mean he was poor. And so he's aspired to, for example, a great looking recreational vehicle, and he obtained a $267,000 and some change loan from a wealthy friend named Anthony Welters. And a Senate Finance Committee investigation found that maybe there was a question of whether the loan was properly reported on his taxes or not. And the idea here is that if Thomas never paid the principal on the loan, it would have created a significant amount of taxable income. And this wasn't reported on his financial disclosure to the court in 2008. And this is the year when Welker said the loan was satisfied. So, this is a problem. And then there's the whole issue of the Koch or Koch, C-O-C-H. Some people like to say Coke. I actually switch back and forth between Coke and Koch. The Koch Network Summit. Thomas attended at least 2 donor summits for the Koch Network, the right-wing political organization, and I'm reading some of this, founded by billionaire brothers Charles and David. David has since passed, and participated in a dinner with high-level donors without disclosing his appearance at the summits or a private jet trip he took to and from the event in 2018. This was reported by ProPublica, and you can go there to look at that. ProPublica also reported that Thomas cultivated a relationship with those 2 brothers through repeated trips to the Bohemian Grove. And the Bohemian Grove is described in this article as a private retreat, quote unquote, a private retreat for wealthy men. I mean, which is kind of funny because if you look at other sites that describe the Bohemian Grove and what goes on there, it's questionable. And anyway, the report noted that the Koch network, and here's where the problematic nature and the need for recusal, which is withdrawal from certain cases that are being heard, where there's an interest that rises to the level of a constitutional violation, which is a very ambivalent phrase. I prefer the appearance of prejudice. I'm going to have to look up the case or the rule that says that, because it's been changed since 2017. There was another case, a Nevada case, I can't remember the name of it, Rippo, I think it was State v. Rippo, with regard to that. And the Koch network has done all these things for him and has subsequently brought cases before the Supreme Court, including staff attorneys representing the plaintiffs in an upcoming case. And this is from, like I say, 2023. So once again, as we're going on about all of this stuff, it's important to understand that if you're receiving financial remuneration from somebody, A, you need to report it, and B, it creates the appearance of prejudice, and it is only the right thing to do to withdraw yourself from any case that is brought by those people or by that organization from whom you received financial largesse. And this is at the heart of the corruption of Clarence Thomas. And so we go on. There's the issue of Sokol, that's Sokol, Huizenga, Huizenga, and Novelli, that's Novely, gifts. Sokol, Huizenga, and Novelli gifts. It was reported that during his tenure on the Supreme Court, Thomas has accepted gifts, including at least 38 destination vacations, 26 private jet flights, VIP sports passes, helicopter flights, private resorts, stays, and a standing invitation for a private golf club, which was almost certainly an undercount of all of the things that he's received from them, particularly from former Berkshire Hathaway executive David Sokol, late billionaire H. Wayne Huizenga, and Apex Oil CEO Paul Novelli. And none of these were disclosed on Thomas's federal disclosure forms. And this is important from the standpoint that, which is almost certainly the case, by the way, and I repeat this so we understand the perspective here. If these entities or people bring cases that come before the Supreme Court and Thomas or any of the justices have received financial emolument or largesse from these organizations or these companies, that is the appearance of prejudice. And I would also not say that this does not rise to the level of a constitutionally intolerable situation. And under such circumstances, Thomas must withdraw from any such case, but he hasn't. And that's one of the problems. Here's the Horatio Alger Association. Thomas is a longtime member of that. And Horatio Alger is kind of a proverbial thing. And the association is created to dispel the mounting belief that the American dream was no longer attainable. And he has for years accepted gifts from a cohort of wealthy and powerful friends who belong to the group, including people with business before the Supreme Court, receiving such benefits as luxury trips and a Super Bowl ring. And again, I state in elaboration that the rule very much is that if you receive financial largesse, emoluments, or any financial benefit from a person who has business before a court on which you sit, you must recuse yourself because of the appearance of prejudice. And again, I also would not say that this does not rise, in other words, it does rise, to the level of an intolerable constitutional issue. Okay, so moving on. This is what we couldn't talk about on the last show because there wasn't any time, and that's why I'm repeating this, because I just want this to be completely clear to my listeners, because these are the people who are deciding your fate, and they decide in many cases most arbitrarily, and that is of great concern. The Supreme Court has been out of control at least since 2001, and the case of Bush v. Gore, which the now deceased Anton Scalia talked about, and it has just gotten worse in the subsequent 20 plus years. So next is the issue of the Harlan Crow trip. Thomas has for years, not just on one occasion, but for years, accepted trips from GOP megadonor and developer Harlan Crow, including on his private jet and super yacht, without disclosing them on financial disclosures as federal law requires. There's also another issue with tuition. Harlan Crow also paid 2 years of tuition for Thomas's grandnephew, Mark Martin, who the justice has custody of, to attend 2 private schools in the 2000s, in the Audis, which cost $6,000 per month at one of the schools and were similarly not disclosed. even as Thomas did disclose the tuition payment a different friend made years earlier. And then there's the issue of Harlan Crow real estate. He's really tied into this guy, Harlan Crow. Thomas and his family also sold a string of properties in Savannah, Georgia to Crow in 2014 without disclosing that as required, including the home where his mother still lives, which Crow told the publication he purchased so he could eventually build a museum dedicated to the justice. Probably gave his mom a life estate to that house, even though he sold it. And now let's pause for a brief commercial message. Hi, this is Jake, and I'm back again to talk to all of you who are business owners. You want asset protection, right? And why? Because you wanted the wealth that you were growing in the business to be protected in the best way possible, and you wanted to keep your personal wealth out of it. But did you know that just creating a corporation or a limited liability company does not guarantee that at all? If you're like me, that makes you feel pretty angry. Do you want to know if there's any way to protect your business and your personal wealth? Well, go to www.jakelaw.me or call me directly now at 573-454-1168, and let's talk about that. Call now. Save your assets now. And now we're back. And so let's talk about Ginny Thomas, his wife, and her conservative activism. Thomas's wife is a right-wing activist, which has raised considerable, understandable ethics concerns about overlap between her and her husband's work. The various sources, like the New Yorker, for example, have reported groups she's been involved with that have submitted briefs before the Supreme Court, again, on which Thomas sits, including a group that has weighed in on the court's pending case once again, this is from 2023, a court's pending case on affirmative action in university admissions. Again, let me repeat, if a sitting judge on any court, not just the Supreme Court, receives a financial emolument or a financial benefit of any kind from a person or an organization with whom the court has business or who brings business before the court, it is intolerable constitutional issue, and it is clearly the appearance of prejudice for that judge to refuse to recuse themselves and sit on the case. Again, repeating that so that it's completely clear. All right, let's talk about Leonard Leo. I've talked about him on the show before. Leo is described in this article as a judicial activist, I'll say. That's kind of an understatement. He belongs to a military order called the Military Order of the Sovereign Knights of Malta. It's an order that was established in the 1200s, in the 13th century, and it exists today. And it's a mysterious, comparatively and nefarious organization. We've talked about it on other segments of the show. We'll talk about it again, and I mention it in passing here. And this organization, and it actually says Leo, but it's done through the Federalist Society, because Leo, who belongs to this absolutely positively medieval organization that hates, almost by definition, hates secular government, has spent billions on efforts to reshape the federal courts and has been startlingly acceptable, which brings us to the retrograde situation that we have on the Supreme Court now, which stunning results on cases like Dobbs, for example, on cases like the 14th Amendment, Section 3, stunning results, completely outrageous. And it's stated in the article, told then conservative pollster Kellyanne Conway to give Ginny Thomas another $25,000 through a nonprofit group he advises, which then filed a brief with the Supreme Court. So this is Leo paying Ginny Thomas almost as a grant in consideration of a case which they had, Leo or one of his groups like the Federalist Society, had business before the court, and paying her, the wife of a sitting justice, on the court where the business was being brought. And then to conceal that the payment was for her, and apparently the comment is that, quote, no mention of Ginny, of course. It goes on to talk about Ginny Thomas extensively. Thomas, it says, pushed efforts to overturn the 2020 election results. That's Ginny. As her husband was hearing cases on it, including sending text messages to the White House Chief of Staff, then the White House Chief of Staff, Mark Meadows, which fueled calls for Thomas to resign or face impeachment over the perceived conflict of interest. And once again, this is an evident conflict of interest. Ginny herself has also confirmed that she briefly attended the rally on January 6th that preceded the attack on the Capitol building. And she further publicly criticized the House January 6th committee. Thomas Clarence has come under fire for failing to recuse himself in the case concerning former President Donald Trump's records being turned over to the committee, in which he was the only justice to dissent, and who states that he believes the records should have been withheld. And here's more about Ginny Thomas. The Post reported in March, and again, we're going back to 2023, but that's okay for the purposes of what we're talking about now, that a conservative group Ginny Thomas formed in 2019 had raised nearly $600,000 from anonymous donors, which was funneled through a right-wing think tank that filed an amicus brief at the Supreme Court during the same time. Ethics experts obviously said Clarence Thomas should have recused himself from that case if his wife was paid by the group. The article further states that Thomas has made a series of other errors, quote-unquote, errors and omissions, close quote, on financial disclosure reports, which the Washington Post reported, and includes reporting real estate income for the decades from a company that shut down in 2006 and has in the past had to amend his financial disclosures multiple times, including after failing to report his wife's income in the 2000s. And when I say 2000s, I mean, the Audis from, 2001 to 2010. Now, this is about all I have on this. This is what I was unable to do in the show where I began talking about this and felt I needed to remediate this and talk about this segment, which now lasted basically a half an hour into an entirely separate show. And again, it's the standard used to be the appearance of prejudice. The standard now, from the days of 2017 State v. Rippo, is when something rises to an intolerable constitutional level where it can't be ignored. I submit to you that all of these things, every single one of them, rises to that intolerable level, rises to that level of the appearance of prejudice. And yet not only has he taken the money and the emoluments and the financial benefits, but he has refused to remove himself from the cases that have been brought. And this is blithe, this is arrogant, this is outrageous, this is hubris, and it ill befits someone who, born in comparatively humble circumstances, in of all places, Pinpoint, Georgia, for crying out loud, to do this way. But he's been corrupted, and he's probably been corrupted partly because of the probably considerable poverty that he was born under. And this is an intolerable thing. Nobody should have to experience this kind of poverty. And according to the Second Economic Bill of Rights, nobody should. But this, of course, is being fought. That is yet another segment for us to talk about. But once again, and so in ending this segment, I think we can just about end it now. We're in the situation of Politics by Jake regrettably saying that Clarence Thomas is a corrupt judge and he needs to be removed from the Supreme Court, or at the very least, he needs to recuse himself from all of these cases and any of these cases. And I would go so far as to say that the cases that he has not recused himself from need to be reheard without him so as to get a more legitimate decision. Of course, you've still got the problem of the other reactionary or fascist judges and the ones like Kagan who say they are progressive, but which I just, actually, I'm not exactly sure that that's the case. But he has to recuse himself. And this is Politics by Jake. And once again, that is all we have time for today. Our next edition will be on the 21st of June. We hope you will be with us for that. If you like what you listen to and you want to hear more, you can check me out at my YouTube page, youtube.com/@politicsbyjake, where I not only have these podcasts, but lots of videos of other material that unfortunately, because of time, we don't always get to on this show. So we'll see you on the 21st at 7 a.m. And until then, stay well and have a great time. Bye-bye.